New Saudi shipping regulation, regulating shipping and marine insurance policy wording. On 4 January 2013, the decision number 112 dated 1 January 2013 ratifying the executive regulation on the activity of contractors of sea good transport, the shipping regulations, was published in the Saudi official gazette Al-Qura. Application and limitation. This shipping regulation shall come into force after 90 days from the date of publication and shall apply to activities of transport of goods by sea through a transport contractor between the port of the kingdom or between the kingdom and any other country or countries. The shipping regulation provision that conflict with any multilateral or bilateral treaty to which Saudi Arabia is a party shall not apply. Licensing requirement. Article 3 of the shipping regulation requires that the person who wish to carry on contracting activities of transporting goods by sea, the contractor, should apply to the Ministry of Transport (MOT) for a license to do so in accordance with the provision of the shipping regulation, provided that such contractors shall necessarily be Saudi fully owned establishment. Foreign investors may apply for such license in accordance with the shipping regulation provided that they comply with any other relevant law or bilateral, regional or international treaty to which the kingdom is a party. The license is issued for a period of 3 years and is strictly to be used by the licensee. The licensee should obtain the MOT prior approval for the opening of any branch or chain of headquarters. Licensees should submit their application for license renewal at least 90 days prior to the expiry date or within 1 year from expiry provided that activities are halted until the license is renewed. Article 13 of the shipping regulation also allows a licensee to transfer its license to a third party subject to fulfilling certain requirements. Pursuant to such transfer, the initial licensee and its personnel remain liable for all obligations that arose during the term of the license, unless otherwise agreed. Insured parties' right and obligation in the transport contract. Article 15 of the shipping regulation provides that the contractor shall link the transport contract to a valid insurance policy which covers the contractor's financial liabilities provided for in this regulation. Article 17 also requires that the name of the insurer, the policy number, and its date shall all be mentioned in the bill of lading. It should be noted that insurance activity and insurance policies wording are regulated by the Saudi Arabian Monetary Agency (SAIMA) and are principally governed by the Law on Supervision of Cooperative Insurance Companies, the Insurance Law, and its implementing regulation, the Insurance Regulation, and the Insurance Market Code of Conduct. This legislation do not provide for specific provision governing marine insurance. However, they do require that policy wording should be approved by SEMA prior to them being offered to clients in the Saudi market. As such, the new shipping regulation have introduced new requirements for marine insurance which Saudi licensed insurers should accommodate in their policy wording. These insurers, nonetheless, may not amend their marine insurance policies prior to complying with the regulatory requirement for their insurance products approval. As per Article 16 of this regulation, the bill of lading should not include anything which limit or affect the contractor's financial right against the sender, or which limit the liabilities of the sender or recipient. On the other hand, the contractor benefits from several limitations relating to delays, deliverables, and other obligations. For example, Article 36 of the shipping regulation provides that in case the contractor is responsible for any delay in delivery, his liability shall not exceed 2.5 times the transport fee of the delayed good and shall never exceed the transport fee of all the goods agreed in the transport contract. Moreover, if the goods are affected by any indirect damage, the amount of compensation shall not exceed the transport fee agreed in the transport contract for such damage, loss, or delayed good. However, Article 38 allows the parties to the transport contract to agree an amount of compensation different from that provided for in the shipping regulation, without specifying whether such indemnification could be reduced or increased. Furthermore, this regulation necessitates that the recipient of goods should notify the contractor in writing of any loss within one business day from receiving the good. In the event that the loss is not apparent, the one-day period shall be 14 days. Moreover, a contractor shall notify the sender in writing of any loss within 14 days from the actual receipt of goods if such loss was a result of the sender's fault or negligence. Principles such as reservation of right previously have been controversial before Saudi court. The new shipping regulation, however, explicitly provides for the reservation of right with regard to deliveries, whilst the commercial law, which used to govern shipping in Saudi Arabia, recognized payment of freight and receipt of goods as evidence of acceptance. Several articles of the shipping regulation give the parties to a transport contract the right to write down their reservation with on the delivery document. Jurisdiction and governing law on violation and dispute. Finally, Article 58 of the Shipping Regulation provides that the Minister Decision Number 119 dated 7/4/2009 relating to the procedures of defecting breaches, enforcement of penalties, payment of fine and examining grievance shall apply to any breach of the provision of this regulation. With respect to shipping, this clearly fills the gap left by Article 20 of the insurance law whereby subrogated claim filed by an insurer against a non-insurer used to be referred to the Committees for Resolution of Insurance Dispute and Violation due to there being no clear regulation governing such situation. It should be noted that SEMA requires all insurers to mention in their policies that any dispute arising thereunder shall be referred to the insurance committees. In light of the foregoing, it would seem that there is potential conflict of jurisdiction and applicable law, especially when it concerns a dispute arising out of a breach of the insurance-related provision of the shipping regulation. Such matters, as well as other aspects arising from the shipping regulation, have yet to be revealed, will only happen when the shipping regulations are applied in practice.